Well, hello everybody. We're on to week 10. Welcome back. And week 10 in the spring semester means that it's getting warm outside, and we're all going to start getting distracted by all the shiny things that are blooming. And just like you, I get the same way. I'm going to start doing my lectures from my deck rather than my study. So um, I feel for you. I know it's getting nice outside, and it's hard to do your schoolwork, but stay focused. Keep your eye on the prize. Only another month or so to go, and take your cell phone with you. Put in your earbuds and go on YouTube and take a walk, or go sit out in the sun while you watch my lectures. Okay. Because we're getting close. So this week we're going to talk about torts of a personal nature. And as I said in the beginning of this 2-week section on torts, don't get hung up on the personal versus the physical, because there's a lot of overlap in that, really, especially when you dig into some of these cases. But let's go over real quick what a tort is and get your mind back to where we started. So what is a tort? A tort occurs when someone either intentionally or negligently causes injury to another person or his property. Torts, different than criminal law, they are civil wrongs. You will find torts all in the common law, and they're not criminal matters, although you could have a tort that stems from a criminal matter. Probably one of the most famous was the O.J. Simpson murder trial, where he was acquitted. Remember, if it does not fit, you must acquit. Johnny Cochran's famous last words in the courtroom. He was found not guilty. Yet there was a civil tort brought for the death of his ex-wife and her companion, and I believe the settlement was around $50 million. I could be wrong on that, and I'll look it up and I'll correct that if I am wrong. But it is not necessarily it's not a criminal matter. A tort is always a civil matter, but it may stem from a criminal matter. And the difference being is that criminal matters are brought on by the government on behalf of the citizenry as a whole, and the penalties may be jail time or prison time versus normally a monetary damage. Now, we also know that some of the terms used to define torts, like assault and battery, are also found in the criminal statutes. So the big thing to remember, again, and you'll hear this over and over because you'll see it over and over, is that a tort is a civil matter always. And the victim files suit and asks the court to award normally monetary damages, but also sometimes some behavioral change can also be part of an award. So one of last week's cases really had me scratching my head because it's a classic case of security people doing too much. And this is normally where security managers and their staff gets into troubles, when they do too much. They go above and beyond. It's feast or famine. Either they didn't react to something they should have, or they overreacted to the thing that they should have just taken a bit more in stride. In this case is Leibowitz versus Sheraton Hotels. The Sheraton Hotel in New Orleans, Louisiana, has a shoe shine stand inside of it, as many hotels in New Orleans and New York and other places have. If you ladies and gentlemen are ever in those cities and you're there for a job interview, I would strongly suggest you go to one of those places and have your shoes professionally signed. It'll run you with tip about $10, and you'll feel like $1 million, and you'll ace the interview, guaranteed, right? But Leibowitz came into the Sheraton Hotel and went to the shoe shine area. He was known to security as a ticket scalper, someone who sells tickets for sporting events at very high prices when those tickets are in short supply. And the police were called by hotel security, and they asked the police to remove him because he was a ticket scalper, giving police the impression that he indeed was committing a crime in the hotel. And Leibowitz sued the hotel, saying that the information they gave the police, which caused his removal from the hotel and his encounter with the police, was caused by the hotel giving false information that he was scalping tickets in the hotel, where he was actually going in to get a shoe shine. Now, whether he was scalping tickets or not is immaterial, because the hotel never did see him, or the security of the hotel never did see him, nor did the police scalping any tickets. And therein lies the the problem, the security people gave the police information based on conjecture and not on actually what was observed. So this particular case, and it's written up in a very short manner in the text if you want to go over it. It's probably a shorter read than it is my explanation. But you have to understand that the Leibowitz case is really something that makes me scratch my head, because hotels or anybody who has private property really doesn't need to provide a reason to have someone leave their premises. If I own these premises and I choose to ask to have you leave, then you must do so. It is not a matter of any real discussion. I am the owner of this property, or the owner's representative, empowered to ask you to leave. Will you please leave? No, I'm not going to leave. I do not need to have a reason. When the police were summoned to ask Mr. Leibowitz to leave, they did not need to have a reason. The only reason was that the owner of the property or the owner's representative asked to have Mr. Leibowitz leave, and he refused to do so. But they gave a reason, and when you give a reason, you must be sure of that reason, because that is the basis then for every action that takes place afterwards. So the reason that I bring this case up, and specifically in this particular course, because there's so many of you that are corporate security majors or minors, is that you should really instruct security personnel to only share with police what is absolutely necessary for them to do their job. In the case of Leibowitz versus Sheraton Hotel and Leibowitz himself, all the police needed to know was, I am the hotel's security representative, and I have asked this gentleman to leave, and he refuses to do so. Those are the facts, period. The fact that he may have been thinking about scalping tickets, that he's been in there before and he's a ticket scalper and we don't want him here, not material. You just wanted him to leave. He didn't go. That's all the police needed to know. So this particular case, Leibowitz was not successful, as I recall, in his lawsuit. However, it really doesn't matter. Security people get themselves jammed up when they give out too much information. Always train your people that they are the representative of the owner, and they can ask somebody to leave without regard to a reason. Now, if they're asking them to leave because of some reason that they choose not to tell people, but that reason in and of itself is a bad reason. I'm asking this person to leave because I don't like their religion, their race, their gender, any protected class, those kinds of things. Sure, that's a problem. But in the case of Leibowitz, they were only asking him to leave because they didn't want him there. Now, they may have not wanted him there because they knew that he was going to be there to scalp tickets, and they didn't want to become that, have their hotel reputation damaged by, illegal activities in the lobby. But all they needed to tell the police was he needs to go. So again, when you train your people, that's what you need to train them in. So this week, as you go through and again do case briefs, just as you did last week, because as you do those and then you read the other case briefs that others have written or read the cases themselves, you will learn. I would like to concentrate a little bit on defamation law, because I think it's something that in the business world and in the security world tends to be something that you need to definitely be aware of and be cognizant of when you may run afoul of it. Defamation is the making of false statements that injure the reputation of another. That's the simplest definition that I could find. I think the important parts are that they injure the reputation. So when we talk injury, when we're talking about defamation, we're not talking about a physical injury. We're talking about injury of a reputation, of standing in the community, professional reputation. And it also includes that element of false statements. If the statements made are true, then they cannot be classified as defamation. And we'll get into that in a bit. Defamation takes on two general flavors, if you will: slander, which are oral statements, and libel, which are written statements. So if I make a claim that you are a child molester, and that claim is false, then I have committed slander, right? I have made a slanderous statement about you. If I write that, let's say in a newspaper or even just in a memo to another person, then I've committed libel, and I've made libelous statements against you and defamed you in that way. But let's get a little bit deeper into defamation and the types of defamation. Generally in the law, defamation is divided into two distinct types of statements, be they written or oral. Defamation per se. Those are statements that are so obvious and naturally harmful to one's reputation on the face that the proof of injury is not really required. Very direct statements that are false statements that injure the reputation and standing of another person would be defamatory per se. Now, defamation per quat statements are less obvious, and they require the plaintiff to prove that there were damages. These are pretty easy to distinguish between the two when you put them into very certain terms. So let's look at defamation per se, because it's the easiest one to define. It's a very strict set of rules that apply to defamation per se. Defamation per se, imputing that a person committed a crime. By imputing, I mean I am stating, right? John killed Bill. I am imputing that John committed a crime. John murdered Bill, right? It's a crime. Murder is a crime, and I'm saying John did it. I have imputed that. If John did not murder Bill, if that is a false statement, then I have committed defamation per se. Imputing that a person is infected with a loathsome communicable disease. That is quite a statement there. I imagine it comes from very old laws. But to say that a person is inflicted with a loathsome communicable disease is defaming them, and that's a defamation per se. It's very direct, right? I'm specifically saying something. Imputing that a person is unable or lacks the integrity to perform one's employment duties. Imputing that a person's lack of ability or otherwise prejudices one in one's profession, right? They're not, if I say directly that this person does not have the requisite training or is not smart enough to do their job and their profession, I have defamed them per se because it's a false statement unless I can prove it in some way. Imputing that a person is engaged in adultery or fornication. Very clear. Brian is sleeping with Sally. Brian and Sally are having sex. I am making a statement, and if it is a false statement, then I have defamed both Sally and Brian. Pretty clear. Defamation per se, very clear statements, and those are the general 5 categories you will see in just about any state statutes or any law book concerning defamation per se, very strictly along the lines of those 5 things. Now, defamation per quat is a little different because you're implying but not outright stating something. Let's say someone says to you, you don't want to do business with that photography shop. I hear their owner likes to take pictures of kids. Now, I did not come right out and say that a crime was committed, but from the way I said it and what I just said, you might be able to infer that indeed that is the case. And if that is a false statement, defamation per quat attaches here. But you must show actual damages. You must, if I made that comment, the photographer, the one I'm talking about, or whoever made the comment, the photographer would have to show that that comment had damages them in some way, either in a business standing or in a community standing, or damages their reputation. But let's look at that exact statement 2 different ways, because you can see how this gets a little bit harder sometimes to distinguish than defamation per se. Same comment. You don't want to do business with that photography shop. I hear their owner likes to take pictures of kids. Now, I asked a friend if I should hire a local photographer to take pictures of my home because I want to sell it for a possible real estate ad. And that's what the friend told me. The friend made the statement because, based on her knowledge, that particular shop specializes in school photography and taking school pictures of kids. And there are many of those types of shops out there, right? There are some that really specialize in taking pictures of senior pictures of kids for high school. Very common to get your senior picture taken, right? I don't know why that started, but it is what it is. And there are some photography shops that really specialize in that. They make a good amount of money doing it, right? Doesn't mean that they're doing anything illegal, but it was the same statement. Same statement I made earlier, I made again. But in this case, the person gave me that answer because they were telling me that that photographer just doesn't specialize in real estate. They specialize in taking pictures of people, right? Now let's take that same statement again. You don't want to do business with that photography shop. I hear their owner likes to take pictures of kids. Now, I asked the same friend, or a different friend, if I should hire the local photographer to take pictures at a family pool party for my daughter's 5th birthday party. And that is the response I got back. In that context, based on me asking, should I hire this photographer to take pictures of my daughter's 5th birthday party with all her little friends around? Someone says, you don't want to do business with that photography shop. I hear their owner likes to take pictures of kids. That in and of itself, the context and the tone, and if the friend was potentially making that statement based on rumors of possible inappropriate conduct by the owner, but those statements are potentially false or cannot be proven, defamation by quat could attach. So we've got the same statement. Now, when we say defamation per se, we say Brian murdered John. I think it was John I killed last time. Maybe it was Bill. But Brian murdered somebody, right? You're imputing a statement that I committed a crime. And if indeed I have no criminal record, then you have defamed me. But defamation per quat is a little bit different because it really is contextual. And the big thing is that the person who was defamed must show that the statement made caused some sort of actual harm. So the statement and context and motive are the drivers of whether the statement is defamatory in this case, right? It's not just the out-and-out statement. The loss of business, in example 1, right? Should I hire this photographer to do my pictures of my real estate? No, I hear they like to take pictures of kids. The person meant that they are a studio that specializes in portraits, children's portraits, and it's very common. It's not malicious on the surface, and it's really not a false statement. In number 2, however, it's due to alleged criminal misconduct, and unless it's true, it is defamatory. So the harm here would be the loss of business, potentially. The reputational hit as well, obviously, because that's what caused the loss of business. But to show an actual monetary loss, they could say, well, this person is saying that I like to take pictures of kids, and they're saying it in a defamatory manner, and I'm losing business, and people won't come near me. My shop is now a pariah in the community, and I have to close. I have definitely suffered a loss. One of the big factors in proofs in defamation of any type is called publication. And I don't want you to get confused with the term publication, like, putting it in the newspaper, right? Publication simply means that it's either written or spoken, and it's a defamatory statement, right? Doesn't have to have a large audience. It can be a conversation between two people. You can defame a third party by having a conversation with someone, just one-on-one conversation. You could defame someone else, and they could indeed initiate a tort, right? Doesn't require this large audience. So in a security context and in a business context, where you see this happen all the time, is when someone leaves the company under a cloud of suspicion. And you will have a supervisor or a manager that will assemble the work group and say, Bill's been terminated for theft. That may be cause for a defamation action, and specifically because you have accused Bill of a crime. And if you as a company did not go to the police and ask, file a complaint, and charges were not filed by the prosecutor, and a trial was not held, and there was no conviction, then you might have a little trouble. You'd have to prove, based on your internal investigation, that Bill did indeed commit theft. But again, remember that one of our rules of thumb here is we just want to stay out of court. Yeah, we could probably win that if we're good corporate investigators. We've done an investigation. We know Bill stole something. We have tons of proof. We have video evidence. But Bill sues us for defamation because a supervisor announced to the work group that Bill's been terminated for theft. We're still going to court. We're still putting together a case. We're still paying for potential outside counsel to help us with it. It's still a business disruption. Our rule of thumb is to stay out of court. Corporate security people don't want to go to court for anything. Saying Bill is no longer with the company is certainly better, and it's enough. It tells people that Bill should not be. Don't hold the door for Bill. If Bill comes up in the morning and you're going in the door and you're using your access badge to get into the building, and Bill's coming behind you, please don't hold the door for Bill. Bill's no longer with the company, and that is all that's required. But again, just like our case with Leibowitz, it is a situation where somebody did too much. They only needed to say Bill is no longer with the company to advise people to not allow Bill access to the building, but instead said Bill has been terminated for theft. Publication is an essential part of any defamation. You need to be able to prove that it was actually said or written, and in defamation per quat, in what context it was done. So why is defamation important to a security manager? Well, because it's one of those things that can bite you, right? It normally happens in a couple of different circumstances. The first one is when you're removing a terminated employee from the premises, and this will happen in your career several times. I was at some facilities that were fairly large. At one point, one operation where I was the security lead had 13,000 people working on a daily basis. It was not uncommon 3 or 4 times a week that someone was being asked to leave. We had a lot of contracted help. We had a lot of temporary labor. That just adds to it because those folks tend to be more transient. But it was not uncommon for me to have to send security officers somewhere to escort someone from the building, right? That's one of the places where defamation can certainly bite you. During background check investigations, especially on reference checks, which is something that I'm going to advise you more than once in this lecture to avoid. You should be doing the criminal histories. You should be doing potentially any civil cases that are documented, but you should be staying away from the reference side. Let others do that. And again, the security manager isn't always the one who's defaming someone, and in fact, in most cases, hopefully they are not at all the one. But they get drug into this lawsuit. And again, we want to stay out of court. So this first case I want to talk about is Phelan versus May Department Stores. May Department Stores is actually the owner of Filene's, which is another department store chain, which I think is still in existence, if I'm not mistaken. 2004, Michael Phelan was a senior accountant at Mays Department Stores at Filene's. And there were some accounting issues that were reported by him regarding some vendor charges. They had a situation where they would charge vendors or charge them penalties if they didn't do things in a certain way, and then vendors could come back and request that those extra charges be taken off and that they be paid in full. And it went back and forth. It was kind of an arbitration thing. It sounded like a hokey kind of a setup. But they were vendor charges and to the tune of $400,000, more than $400,000, which were not properly accounted for, and that Filene's was on the hook to pay back to vendors. Filene's execs started the investigation. Phelan actually didn't seem to be the person of interest in this, and in fact, it was a person who worked for him who was burying these things. But while the investigation was going on, the executives at Filene's had a security person stay with Phelan the entire time he was at work. He was escorted from one office to another, from one conference room to another when he went to the restroom. They did not want him, number one, using the phone, and number two, going to visit anyone who was under investigation. Those who have taken my investigations class know that you talk to people quickly. You don't try to spread it out too far because people will talk to each other. And you can't really control that, right? As much as you want to, you can't always control it. But in Filene's executives' infinite wisdom, they put a security person with Phelan, and he walked around all day. Phelan was eventually terminated, I think because it was his department, and he should have known that there were problems. I guess was the wisdom there. But he filed a defamation suit, claimed defamation per quat, alleging his reputation with coworkers was irreparably harmed. So here's what's at issue with this particular matter. Is the appearance given by Phelan being escorted by security guards a matter of publication? No one wrote anything. No one said anything. But the fact of the matter is Phelan, who was a senior accounting person, was escorted at all times while at work by someone who was an obvious security department employee. Everybody that saw him in the hallway, anybody who saw him in the restroom, knew that there was a security guard with him all the time. Did that constitute publication? Did that also cause irreparable harm to his reputation? On the surface, it's almost easy to say yes. And did he show a true loss? Because it's required in a defamation per quat. Remember, in per se, it's automatically assumed that someone accusing you of a crime or accusing you of adultery or accusing you of not being able to do your job is harm enough. In a defamation per quat, which is what this is, or is alleged to be, you have to show a loss. So, was there publication? Did it cause irreparable harm? And can he show a loss from that harm? Now, truly interesting to me is that in 2004, the Massachusetts Supreme Court found the simple escorting of Phelan did not rise to publication, even though it was done all day, and it was obvious who the escort was. It wasn't obvious why it was going on, but they found that did not rise to publication. He didn't present evidence of irreparable harm to his reputation because he did not during the court proceedings, he didn't have co-workers testify to the fact as to whether or not his reputation had been harmed. That just seemed to be a really bad way to represent yourself in court. And true loss in this case could really only be shown when he went to his next job. If he went to try to get another job, he was terminated because he should have known that there was an accounting anomaly going on in his accounting department, right? He was responsible for that. That is what they terminated him for. But if he went to his next job and his reputation had been harmed because, oh, yeah, you're the guy who security was following around over at Filene's. We know who you are. No, we're not hiring you. He could have shown harm. So in this particular case, the court said there was no publication. However, and in fact, in this week's court briefs, case briefs, I'm going to ask you to find a case, not one that you briefed on, one of the others, where you disagreed with the court's findings and to tell me why you think you disagree. Give me some good reasons based on the lecture why you think it may have went the other way. In this case, my personal opinion is that when you walk around all day with a security guard tied to your hip and everybody knows there's investigations going on, I would say that basically the company is saying that you are in some way involved. That to me is a public statement. There has been publication, but the court didn't find that way. But again, he filed the suit, and the security people and the executives all had to take time and had to go to court and had to spend the money on defending themselves. Our job is to stay out of court. Therefore, having somebody walk somebody out can be a problem for you. So what did we learn? Security escorting an employee is not in and of itself a defaming act, right? Security does escort people out of buildings when their job has been terminated, and that in many ways is to make sure, number one, that they don't take any proprietary information or property, that they're not accosted by anybody on the way out for their own protection, and that they follow the most direct route to the exit so that they're not disrupting the workplace. There's a reason for that. But the way the employee is escorted can give rise to publication. If you do a perp walk with somebody, okay, the president of the company is getting fired. Let's take the long way around through all the office cubes to get them out the front door so everybody can see this guy walking with his cardboard box full of his wife and kids' pictures and his personal effects. Let's embarrass him here. You are definitely going to give rise to publication without regard to what the Massachusetts Supreme Court said. Really, their opinion was that it wasn't enough to just be escorted, but to be escorted through areas potentially where you didn't need to be, to do the perp walk would definitely give rise to publication. His case was flawed because of the testimony, obviously, of his not available for his coworkers. But terminations are where the security manager gets involved, and if they can be done remotely, they should be done that way. Call the person on the phone. You put someone on administrative leave when an investigation comes up. We've talked about this in one of my other classes, but those who haven't taken it, when there's an investigation and you need to keep somebody at bay, you put them on administrative leave and you ask them not to talk to others, right, if allowed. And if they need to be terminated, you do that by certified letter, delivered the same day. You have it delivered saying your job's been terminated. We will pack up your personal effects and we will send them to you. And that is exactly what you do. Okay? There was a false imprisonment claim, quite frankly, on the same tort, which was shot down, and I think it should have been shot down because although the security guard walked with him everywhere he went, he was free to go. He could have left. So if you read this case, the false imprisonment charge was dropped, or complaint was dropped right away, and it was found that to be invalid simply because he could have left. He wasn't being held against his will. He was just being followed everywhere so that his actions were controlled while he was in the building, but he could have left the building. So again, just having a security person escort somebody is not in and of itself publication, but it can be if you do it the wrong way. As a security manager, make sure you understand and you train your people on how to effect a termination and what their role is, and that is simply to walk the person from the location where the termination took place, the most direct route to the exit, so that they can leave the premises of their own accord, and to do it low-key and not publicize it in any fashion. The next place where security managers tend to get bitten by defamation is in references. And I don't understand why employers give references at all. I mean, they're just so littered with opinion. They're seldom really accurate. It's more, and everybody reads into them. They're really just a bad practice, in my opinion. I know you want to understand, the history of somebody before you hire them, but asking for 3 references. If you can't find 3 people to say something nice about you, you have really lived a horrible life, okay? And so they have very little value. But sometimes the opinions people give in these things are considered to be fact, right? Someone may say, Brian wasn't promoted here because he wasn't competent at his job. Now, that is a defamation per se. You're saying that I wasn't competent, that's why I wasn't promoted. Now, I can sue if there was another reason. Maybe I didn't have the prerequisite education. Maybe it required 2 doctorates. Maybe the job said you needed to travel 40%, and I have young children at home, and I chose not to try for promotion. I might have just had poor relationships with others. I can be a real jerk, right? But it wasn't because I wasn't competent at my job. There are many very, very competent people who are jerks in the workplace, and you will run into them, I'm sure, if you haven't already. But if someone says I wasn't promoted because I wasn't competent at my job, they think they're giving an opinion, but they're really doing is defaming me directly. So it's a trap. And opinions can be allowed, right? But they can be magnets for accusations, and again, lead us to court. I think Brian had a negative attitude. Somebody could say that in a reference, what did you think of Brian? Well, I think he had a negative attitude. Now, if Brian was a coworker and I said that, most people say, well, okay. Sounds like he didn't get along with everybody. But what if I'm the HR director? What if I was Brian's direct boss and I make that comment? Am I not making it from a position of authority, and therefore my opinion is being construed as fact, and now I have potentially defamed, in this case defamation per se, because again, I'm saying that you can't do your job. This might actually be a per quat because it's a little bit less direct, but I think you get my point here is that in references, opinions tend to become facts, and they tend to become problematic. But how about if you're holding something back, right? In that, so we're saying, don't give this reference, but what about holding something back? Can you get a lawsuit for giving a good reference if the worker was a bad person, if they were a criminal, have dangerous tendencies? The answer is absolutely yes. In the case of Randy W., who's a minor, versus Muroc Unified School District, Fresno, California, Robert Gaddams was an employee of the school district, and there were multiple and serious claims of sexual misconduct against Gaddams. The school, in a way to try to distance themselves from Gaddams, gave him a glowing letter of recommendation and told him to move away, told him to go away. They did not report the allegations to the police, and they gave him this glowing letter of recommendation to say, look, here, just go start your life someplace else. We want you out of here. And a new district hired Gaddams, partially based on that glowing recommendation from Muroc Unified School District. And Gaddams sexually assaulted a student at his new place of employment. So what's at issue here? Well, did Muroc USD publish a false statement? The false statement doesn't necessarily have to be a bad thing. It can be a false good statement. In this case, they gave a glowing recommendation to a sexual predator. Did their actions cause irreparable harm to Randy W.? And did Randy W. show a true loss or harm? That's really what we're looking at here when we're talking about a defamation case. And this really classifies as a defamation case because the court found the letter, that glowing recommendation, to be an affirmative misrepresentation. of his suitability for employment. It was a false statement. And because Muroc Unified School District made that false statement, they became the person who defamed, right? It sounds in reverse, but it's the same concept. Randy W. was harmed. There was a criminal investigation that found Gadams guilty of sexual misconduct against a minor. And so, definitely Randy W. and others were able to show that they were harmed because of this misrepresentation of the facts, right? The affirmative misrepresentation. The court, ironically, also in their decision, reminded Randy W. and others that the failure of the school to report these initial allegations from the first children who came forward was also a violation of law, to which they could then use as the basis for a second tort against the school. The settlement was not disclosed that I can find. I've looked at this case from several different angles and I've not found a disclosed settlement. A lot of times these things are sealed, but there's no question that the school district had to pay damages to Randy W. and likely to others because they made false statements and published those false statements, and that publication caused harm to someone. In this case, it was because they published something good that shouldn't have been published. So it's a situation in references of damned if you do and damned if you don't. So many companies in the last several years have gone to a policy of this is what we give in a reference: the date of hire, the date of separation, the beginning wage, the ending wage, and the job title. Is that safe to do? Not really, because not disclosing anything is just as bad. In the case of the Randy W. case, the school district did not disclose what they knew and, in fact, tried to hide it in an affirmative misrepresentation. So it's a classic catch-22 on references, which is why, as a security manager, there's certain things you can do to protect yourself. So what is definitely safe? Well, spelling words right is definitely safe, right? Definitely safe, criminal convictions. Criminal convictions, when they're public and you can show them, it is safe to ask about and to investigate and to publicize to your HR person or the hiring manager, whoever, a criminal conviction. The same with documented civil judgments, if it's related to the job. This person has sued the last 5 people that have hired them. And I actually had an employee that didn't report to me, reported to a friend, and after hire, we found out that he had sued every one of his last 5 employers for age discrimination. And then, once hired, came on the job and did absolutely nothing. None of his work, nothing. He just came into work and sat. And then waited to be fired and then filed a lawsuit. But those civil judgments could have definitely come into discussion. They were not false statements. They are facts, and they're provable because the cases and decisions existed. Verification of residence and actual employment listed by the applicant. So did this person actually work in these places? Right? Is there a gap in their employment? Right? Verification of residence. Did they actually live somewhere? Can they prove that? Do we have a history and do we have proof they live somewhere that they purported that they did? They made the statement, I worked at ABC Company and I lived in Fresno, California. You can go ahead and verify those things. Military service, another. Most applicants are asked if they have any military service. If they say yes, you can verify that military service. And if they made a false statement, you don't need to hire them. But I would suggest you let HR do the rest. Security people's specialty is in checking criminal convictions, court records, and verification of residence normally. It's something we can do well because we normally have the tools available to do that. We don't have the tools nor the skill set to talk to other employers about a person to get a reference. That is an HR type function. And although I hate to throw work over the fence at someone else, it is one of those few things that I would highly recommend that you talk to your HR people when you start in the first job. If you're the one doing the background checks, if you haven't contracted that out, then I strongly suggest you talk to them about doing the reference checks. That is a specialty that a personnel specialist should work on, not a security person. So that's it on torts of a personal nature. They really are. The injury or harm is not physical. It's generally reputational. The community, workplace, or professional standing of the person is harmed, right? They don't bleed from this, but it may impact their employability. It may impact their standing in the community, their standing in their profession, their ability to get jobs or new clients. is often something that is considered the injury in this case. The reasons in the workplace for torts of a personal nature, for defamation especially, is usually related to overzealous actions of the managers, their agents, security, HR. Somebody does something they didn't need to do. And that normally comes back to the publication side. And that can take many forms. Again, announcing in a work group that Bill has been terminated for stealing or for theft is a defamation if you can't definitively prove that theft or stealing. But the manager didn't need to say that. The manager just needed to say Bill is no longer with the company. And that would have been enough to get the same. But people get overzealous. They do too much. They tell police that the guy is here to scalp tickets when indeed all you know is that he's here and I don't want him here. Okay? Defamation per se derives from direct published statements. Defamation per quat derives from implied published statements. Just remember the two. And you will be asked in the future about the two. You'll be given examples and you'll be asked which one is it, or is it either. So just make sure you understand the difference between those two. And maybe I should have switched these first two sentences because statements of security personnel can rise to defamation per se. Security people tend to talk too much. And they'll often say, well, so-and-so, well, he was, he's been arrested for this, or he's definitely a rapist, right? Well, unless he has been convicted of that, you have just defamed that person because you can't prove it to be a true statement. It is not incumbent upon them to prove it to be false. You made the statement, right? But the actions of security people can rise to defamation per quat. Just the effects of taking somebody out of a building when they've been terminated or when it's time for them to go, not doing it in the right way, can lead to that implied defamation. Bad references can lead to defamation actions. So can good ones, right, when they're not true. So giving somebody a good reference, even though they weren't good on the job, can come back and bite you just as it did with the Randy W. versus Muroc Unified School District case. Security managers doing background investigations should stick to criminal and documented civil records, period. Don't get off into tangents with talking to people and getting their opinion. First off, opinions, everybody has one. They're not all correct. You really don't want to go there. You want to look at criminal records. You want to look at documented civil records. You want to look at verification of identity, verification of residence, and gaps in employment. And report those to the hiring manager. Remember, you're doing a report, not a background clearance. You're doing a background report. You're just listing the things that you find, and someone else makes the decision. I would not go into discussions about someone's qualifications other than those that are in documented records. That is how security managers get themselves into trouble. So this week we wrapped up our discussion on torts, although just about every unit will have some level of torts in it. In fact, if they're not criminal, then they're normally civil, and it will be torts. So we'll be touching on them again, but this is our specific second week. Lecture is done. Thank you very much for your attention. We're going to read the cases in the text in Chapter 5. You're going to be assigned your case as you were last week. You're going to use the IRAC plus example method to brief on the case. Your case briefs are due on Thursday at 11:59 p.m. per usual. You're going to make one response comment this week, but I want it to be a little bit longer. In fact, I'm going to put a 150-word minimum on it because I think that's just minimal. That's just a paragraph or two. But you're going to tell us why you think the court may have erred in their decision. What did the court say in one of these cases, not the one that you briefed on, but one that somebody else briefed on? Read their court case and say, I think the court erred because, and it can't just be your opinion. I think they erred because this doesn't seem to rise to publication, or the defamation or the actions didn't do this or did that, right? And maybe the person should have paid damages and maybe they didn't. Maybe they did and they shouldn't have. But I want you to give me some logic as to why you think the court may have erred. Doesn't make a difference. We all have opinions, but I want yours to be a qualified opinion where you give me some facts and show me that you understand the different elements of torts. That's due on Sunday at 11:59. Make sure you're familiar with all the cases, because in our meetings on week 14, we are going to discuss all of them in some fashion when I bring up the scenarios. With that, have a great week, and I will see you on campus.